Welcome to the Courtroom Club. Today we're diving into something pretty critical in corporate governance. The whole process of removing a director from a South African company. It sounds straightforward maybe, but it's actually a really complex legal challenge.
It absolutely is. This isn't just about a disagreement, It's a significant legal action.
Right.
And because it's so significant, it's really strictly governed. We're talking about the Companies Act, Act 71 of 2008. It's all designed to make sure things are done fairly.
Okay, so fairness and procedure are key. Our mission then today is to really pull apart that framework, look at the legal reasons, the grounds you need, and importantly, the step-by-step process you have to follow to, well, stay on the right side of the law.
Exactly. Get the roadmap clear.
So where do we start? How does the company actually kick this off? What are the main legal paths?
Okay, so there are basically two main avenues you can go down, and they're quite different.
Right.
The first one, and it's generally the most powerful, is removal by shareholders' resolution, specifically an ordinary resolution.
Ordinary, so simple majority.
Yeah, usually. Section 71 of the Act covers this. Typically needs holders of at least 50% of the voting rights to agree at a meeting. The key here, though, is that the procedure must be followed to the letter.
Interesting. So you're saying if the shareholders just decide they want someone out and they follow all the procedural steps perfectly, they might not even need to prove, say, incompetence.
Well, that's often the strategic advantage of the shareholder route. The Act gives the ultimate power to the owners. Now, obviously, having grounds makes it smoother, less contentious, but strictly speaking, for shareholders, the power often rests on correct procedure under the Act.
Okay, that's quite powerful. What's the second path then?
The second way is removal by the board of directors itself, but this is much more restricted.
How so?
The board can usually only remove one of their own for very specific reasons. Think serious misconduct, maybe incapacity, or some kind of status change like insolvency. And here's the really crucial part. The board can only do this if that power is explicitly written into the company's own rulebook, the Memorandum of Incorporation, the MOI.
Ah, okay. So the MOI is like the internal law for the board on this. If the MOI doesn't say the board can remove a director,
Then they can't. Simple as that. Even if the situation seems dire, they'd have to go the shareholder route.
got it. So you've got the shareholder power, often procedure-focused, and the board power, which is much more limited and depends entirely on the MOI.
Exactly. And the big takeaway is you have to comply with both the Companies Act and your internal documents, like the MOI or any shareholders agreement. One doesn't override the other. You need to tick all the boxes.
That makes sense. It's navigating two layers of rules.
Right.
Okay, let's shift to the why. If removal is based on cause, maybe the shareholders want to justify it, or the board is acting under its MOI power, what are the legally recognized grounds? What reasons actually hold water?
Right. You need a solid, justifiable reason. It can't just be, a personality clash. The Act and case law point to several key areas.
Such as,
Well, the most serious is probably a breach of fiduciary duties,
meaning,
acting dishonestly, putting their own interests ahead of the company's, or actively working against the company's best interests. That's a fundamental violation.
okay, that's pretty clear-cut if you can prove it. What else?
Then there's general mismanagement or incompetence. But there's a nuance here.
Oh,
Yeah, proving legal incompetence isn't just about bad decisions. Everyone makes those. It's more about a consistent failure to meet the basic standard of care expected of a director, and that failure causing harm. It's a higher bar than just poor performance.
so not just a bad strategy call, but a real failure to fulfill their duties.
Exactly. You need evidence of that failure. Then you also have things like a clear conflict of interest.
Right, where their personal dealings clash with the company's needs.
Precisely. And more practically, things like chronic absenteeism. Just not showing up for board meetings repeatedly without a good reason. It shows they're not fulfilling their role.
Okay, and I suppose there are also situations where it's almost automatic.
Yes, the status changes. These are often less debatable. Things like the director being declared insolvent or being convicted of certain serious criminal offenses. Those often trigger disqualification under the Act anyway.
So those are sort of non-negotiable grounds?
They tend to be, yes. Legally cleaner, you could say. But for the others, like incompetence or breach of duty, the company really needs to have its ducks in a row. Documentation, evidence, it's crucial for the next part, the process.
Absolutely. Which brings us neatly to the roadmap. If you have the grounds, or you're using the shareholder route, Following the correct procedure is everything. It's what protects the company from legal challenges. So let's walk through those steps with number one, the absolute starting point.
Step 1 is homework. Review the MOI and any agreements. Before you even think about sending a notice, you dig into the company's memorandum of incorporation and any shareholders agreements.
Why is that so critical first?
Because those documents might have specific rules that go beyond the Companies Act. They might dictate longer notice periods or require a higher voting percentage, a special resolution instead of an ordinary one, or even outline a unique procedure. If you miss that, your whole process could be invalid from the start.
Know your own rules first. Okay, makes sense. What's step two?
Step 2 is about fairness, which, as you said, is core to the Act. Notify the director.
Formally, I assume.
Oh, absolutely. Formal written notice. And it needs to be detailed. It must clearly state the reasons, the specific reasons for the potential removal, maybe summarize the evidence, and state when the meeting will be held.
And the purpose of this is?
To give the director a genuine opportunity to prepare a response or a defense. It's not just ticking a box. The notice has to be substantial enough for them to understand the case against them. It's their right.
Right, procedural fairness kicking in early.
Yeah.
That leads to step 3, which is the actual decision-making part.
Yes. Step 3, pass a resolution. This is where the vote happens.
Okay, so how does that work depending on the path we talked about earlier?
Right. If it's the shareholders driving it, you need that ordinary resolution, typically 50% plus 1 voting rights passed at a properly called general meeting. All the rules about quorums, proxies, voting, they all apply.
And if it's the board acting under the MOI?
Then the board passes its own resolution at a board meeting. But again, only if the MOI allows it, and only after following all the notice and meeting requirements for board meetings.
Okay, the resolution is passed. Now, step 4. You mentioned this is often where things get challenged.
Yes, step 4 is absolutely crucial and probably the highest risk area. Follow due process. This goes beyond just the initial notice.
What does it entail?
The Companies Act is very clear. The director must be informed about the meeting where their removal will be voted on, and critically, they must be given a reasonable opportunity to make their case, to present their side before the vote is taken.
So they get to speak at the meeting.
Yes. They have the right to attend, the right to see the evidence against them, the right to present their own arguments, documents, maybe even have a legal rep speak for them. You can't just notify them and then vote in their absence without giving them that chance to be heard by the decision makers.
So short-circuiting that defense opportunity is basically inviting a lawsuit.
Pretty much. It's a fundamental breach of procedural fairness, and courts take that very seriously. Get this step right, document that they had their chance, and you significantly reduce your legal risk.
Okay. Due process, fully observed, resolution passed. What's next? Step 5.
Step 5 is formalizing it with the outside world. Notify the CIPC, the Companies and Intellectual Property Commission.
How's that done?
You have to file a specific form, the Core 39 form. This officially updates the public record to show the director has been removed. You'll usually need to attach supporting documents like the meeting minutes and the signed resolution.
And if you don't file this Core 39, big problems. Legally in the public register, they might still be listed as a director. This could mean the company is still bound by their actions, potentially impacting bank mandates, contracts. It's a mess. You need to update the public record promptly.
So it's not truly done until the CIPC is informed.
Yeah.
Got it. And the final step, step 6.
Step 6 is the internal wrap-up. Handle final formalities.
Like admin stuff.
Sort of, but important admin. You need to update all internal company records, change bank signatories if they were one, revoke system access, amend contracts where their name appears, and importantly, communicate the change appropriately to staff, banks, key clients, other stakeholders. Manage the transition.
Okay, that 6-step process seems quite thorough. Review MOI, notify director, pass resolution, ensure due process, notify CIPC, final formalities.
That's the core roadmap, yes. Follow it carefully.
Right. Now let's get into some of those messy, real-world questions that often come up. The tricky bits. For instance, can you actually remove a director if they're digging their heels in, refusing to go, if they fight back hard? Yes, absolutely. That's really the whole point of having this formal legal process. If a director won't resign voluntarily, the company doesn't just shrug. It proceeds with the formal removal steps, the notice, the meeting, the resolution, the due process.
So their consent isn't required.
Not at all. As long as the company follows the legal procedure meticulously, particularly that due process step, the removal is legally effective, whether the director agrees with it or not.
Okay, but if they are removed and they feel it was unfair, What can they do? What's their legal recourse?
They can challenge it in court. That's their right.
On what grounds, typically?
Usually they'll argue the procedure was flawed. Maybe they'll say the notice wasn't adequate or they weren't given a real chance to state their case, that step 4 due process failure we talked about. Sometimes they might argue bad faith, but procedural flaws are common claims.
And if the court agrees?
If the court finds a significant procedural defect under the Companies Act, it can declare the removal invalid, which could mean the director has to be reinstated. That's obviously a very awkward and potentially costly outcome for the company.
Yeah. Underlines the need to get the process right. Okay, another common one, especially in smaller or family businesses. What if the director being removed is also a major shareholder? Does removing them as a director affect their shares?
That's a really important distinction. Being a director and being a shareholder are two separate legal hats.
Okay.
You can remove them from their director role, their management position on the board, by following the process we've discussed. But that removal in itself does not automatically affect their shareholder rights. They still own their shares.
So they lose their seat at the board table, but they still own part of the company.
Exactly. They remain an owner with all the rights that come with that: voting rights at shareholder meetings, rights to dividends, etc. They just no longer have the power or responsibilities of a director.
Is there any way around that? Can you force them to sell their shares?
Only if there's a pre-existing agreement in place, like a specific clause in the MOI or, more commonly, in a detailed shareholders agreement that explicitly states that if a director is removed or resigns, they are obligated to sell their shares, often back to the company or other shareholders, usually at a pre-agreed valuation method.
But without that specific clause?
Without that explicit agreement, no. You remove them as director, they keep their shares. Period.
Good to know. Finally, let's touch on timing. We've talked about notice periods, meetings, CIPC filing. Realistically, how long did this whole process take? Are we talking days, weeks, months?
Definitely not days. You've got statutory notice periods, often 10 or 15 business days for meetings, depending. You need time to properly prepare the notice, allow the director time to respond, convene the meeting formally, then file with CIPC and wait for them to process it, which can take a little while itself.
So weeks is more realistic.
Yeah, several weeks is a much more realistic minimum time frame. If it's contested or complex, it could stretch longer. Trying to rush it is usually where procedural mistakes happen, which, as we've said, opens the door to legal challenges. Patience and meticulousness are key. So if we boil it all down, removing a director in South Africa isn't really about winning an argument or proving someone was bad. It's about executing a very precise, legally defined procedure. Compliance with the Companies Act, meticulous adherence to the MOI and any agreements, that's paramount. And that procedural fairness, that due process, it's not just a nice to have, it's your shield against legal risk.
That focus on procedure really stands out, and it leads to maybe a final thought for everyone listening. This whole legal structure, especially making sure the director gets a fair chance to defend themselves, it seems designed to balance two things, doesn't it? Protecting the company's interests on one hand, but also protecting the individual director's rights on the other.
That's the tension it manages.
So the question to ponder is, when a company really commits to providing that rigorous, fair, formal defense opportunity, even if it feels counterintuitive when you want someone gone, how does that commitment to procedural integrity actually end up protecting the reputation, the stability, the overall legitimacy of the board itself in the long run? Something to think about. Thank you for joining us for this deep dive into a complex piece of corporate governance. We hope this was valuable, and we look forward to exploring the legal landscape with you again soon here on the Courtroom Club.